Good morning. Today's another California court holiday, and I am going into the office. I got some of my own cases to work on. I've got some cases for a couple of attorneys that I have work to do on. So, make hay while the sun shines, right? Bills don't pay for themselves. Some of us have to be responsible members of society, and we can't live in our vans traveling around the country filing pro se lawsuits that are deemed to fail. Doomed to fail? Sure. So, a gentleman who is pretending to be an attorney with 26 years of experience didn't understand probable cause and a not guilty verdict, or having a lower court's guilty verdict overturned on appeal. So let me just see if I can't explain this again for the slow boys in the audience. Probable cause is a completely different thing than a conviction. They're handled at two totally separate ends of the case. Probable cause examinations or probable cause determinations are usually done at the very beginning or close to the very beginning. And of course, conviction is after trial. It's at the very end, right? And they do two different things. The probable cause hearing is a constitutional requirement that the court find that there's probable cause before they can proceed with the criminal trial, before they can proceed with the criminal case. You aren't entitled to a jury on it. It's going to be the court that determines probable cause as a matter of law. I mean, they look at the facts, but it's the court's determination, I should say. In some states, it's a very quick procedure, at least like for minor offenses, like misdemeanors, like Chile would have had, where they don't even call witnesses. It's just in front of the judge. It's just a reading of the police report, and they could set it for more hearings apparently in Texas. I don't practice law in Texas, but I do watch some court videos from time to time, and I've seen the practice in Texas, at least in misdemeanor courts, where basically the prosecutor just reads the police report and the judge determines from the police report whether or not there was probable cause. They don't call witnesses, although they can set it for an evidentiary hearing if they want to. Other states like California, we have a preliminary examination, which is a probable cause hearing, where the state has to produce witnesses, generally speaking the arresting officer or maybe any other officers, and the state has to prove to the court that a crime was probably committed, that each element of the crime was probably committed, and that you probably committed them, all the elements. It's a constitutional requirement, but it makes a lot of sense. Why waste everybody's time and money on a trial if the officers can't even show probable cause? If the state can't show probable cause, which is a very low burden, that all the elements of a crime were committed by you, then there's just no way they're going to make that high burden of showing beyond a reasonable doubt that every element of the crime was committed by you. Trial, on the other hand, it happens at the end. Each side gets to present witnesses and present evidence. You may have a right to an attorney. Constitutionally, it kicks in if you're facing a charge of, I don't remember if it's greater than 6 months or 6 months or more off the top of my head, but I think it's 6 months. 6 months and you're entitled to a jury. Some states have lower constitutional limits. I think Texas, for any criminal infraction or crime, you're entitled to a jury, even if it's just a fine and no jail time. So, check with your local state, check with a local attorney, but your odds of being entitled to a jury trial are much higher at trial than they are at the preliminary examination, because you don't get a jury at the preliminary exam. The times when probable cause determinations are challenged are usually, in my experience, in one of two places. Number one, if you're If you're trying to get evidence excluded based on like fruit of the poisonous tree, like say for example, there's a traffic stop, and then once the traffic stop happens, the officers find evidence of some other crime, right? Like drinking and driving, or like a firearm in the vehicle or something like that. In order, as a way to exclude the evidence, you might challenge the probable cause hearing. You might appeal the probable cause determination to try to get that evidence excluded. That's usually when a probable cause determination is challenged on appeal, if you're trying to get evidence excluded. The other way that you might be appealing a probable cause determination is in a civil case. That's when you would appeal probable cause determination by the court. If the court finds, like if the court does a 12b6 motion to dismiss, not if the court does, if the defense does a 12b6 motion to dismiss in like a 1983 lawsuit, where the court finds that that there was probable cause and therefore it's not an unlawful arrest, you might appeal that decision, that finding by the court on the motion to dismiss. You might appeal that. Now, it's technically not a probable cause determination, but it is kind of a probable cause determination. That's why I say there's really one of two places you would appeal that. Appealing a conviction is entirely different. If you appeal the conviction, it doesn't overturn anything other than the conviction. The Court of Appeals, whatever, in Chili's case, it was, I believe, a district court, because they were appealing a municipal court decision. And in the way that Nevada is set up, the district court, not district court of appeals, it's a normal trial court, but they handle all the appeals from the municipal court. And they're the court of final determination for municipal court issues. So you can't even, generally speaking, petition the Supreme Court for a determination of the district court in Nevada, my understanding. There are some exceptions, but generally speaking, the rule is that they're the court of final determination for a municipal court conviction. So the district court, in looking at the appeal from the municipal court, is only looking at, number one, the issues that are preserved for appeal and are raised in the appeal to the district court. Now, I don't know that there's any reason why you couldn't necessarily challenge probable cause, but it doesn't make a whole lot of sense to challenge probable cause, because all you have to do is say that, they couldn't find beyond a reasonable doubt all of the elements of a crime, and they couldn't show beyond a reasonable doubt none of the elements of any defense. All you have to do is beat the higher one, the conviction, that says you have to prove beyond a reasonable doubt, blah, 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 and you don't have to challenge the lower one that says that just a crime was probably committed and you probably committed it. So this is the one that is normally challenged, and this is the only one that matters. The probable cause doesn't matter for the purposes of the conviction if you get rid of the conviction. So Chili did not appeal the probable cause determination that was found by the municipal court in the Nevada versus Decastro case that he appealed. He didn't challenge it. He didn't appeal it. It was not appealed. The district court in the appeal did not address probable cause. In the order granting the appeal that Chili's attorney drafted and submitted to the court for signature and that the court signed, did not address probable cause. Probable cause has never been overturned. A finding of probable cause has never been overturned in Chili Decastro's Nevada case that he was convicted on and then overturned on appeal. It was never challenged. It was never overturned. The only thing that was overturned is the conviction. Now, Chili's attorney probably had a great time at Chili's expense drafting that long-winded and frankly irrelevant opinion, the order granting the appeal, which is great. It's not published anywhere. It's not going to go into some law journal or anything like that. It's a district court appeal of a municipal court case. It's not going anywhere. It's not precedent. It doesn't mean anything. But let's just play pretend. Let's just play pretend. Let's pretend that it did. This is a hypothetical. It didn't, but let's pretend that it did. That is a state case. Chile sued 1983, 42 U.S.C. 1983 in the federal district court. And they are two separate and distinct courts. Just like the trial court, the municipal court's determination of probable cause isn't binding on the federal district court, so too the district court that sat in appellate jurisdiction over the municipal court case, their determination, if they had made one, which they didn't, again, but we're playing pretend, their determination of probable cause not existing is also not binding on the federal court. They're two separate courts. They're two entirely separate courts. So any attorney who tells you, or anyone claiming to be an attorney, I should say, who tells you that somehow that appeal, that order on appeal, that the finding on appeal, however they want to phrase it, is dispositive of the police officers not having probable cause, they are absolutely 100% unequivocally wrong. They're wrong. My point was, and has always been, that after 3 courts look at probable cause and find either probable cause or something greater than probable cause, because the municipal trial court found that there was beyond a reasonable doubt evidence. So, so legally speaking, the way this works is if a court makes a determination of facts at a higher level of proof than what's required in another case, for example, generally speaking, res judicata applies. It's already been determined at a higher level. But if the court makes a determination at a lower level of facts, it's not binding on a court where there's a higher standard, higher burden of proof. Just like a finding of probable cause doesn't mean that you're guilty, a finding of guilt does mean that there is probable cause. You see it in civil cases sometimes too. For example, I have a case where I am representing the plaintiff. They got a restraining order in a civil harassment restraining order hearing, and then they're suing separately for damages. The order of the court granting the civil harassment restraining order, which in California requires clear and convincing evidence, which is a higher burden of proof than preponderance of the evidence, means that when I go to court when I go to trial, if I don't settle it, when I go to trial on the damages for various things like defamation, disturbing the interference with quiet enjoyment. I forget the actual cause of action, what it's caused, because it's early and I haven't had a lot of caffeine yet. But when I go to court on those issues, the facts that the trial court found on the civil harassment restraining order are going to be binding, because it's the same court system, California State Superior Court. It's going to be binding on the trial court in the civil case, because it's already been found by clear and convincing evidence, and that's a higher burden than the preponderance. I hope that makes sense. I know I get long-winded in explaining these things. But any lawyer or pretend lawyer or somebody claiming to be a lawyer on the internet that says that the appeal overturning the conviction is somehow dispositive in the federal court is absolutely wrong. But the fact that 3 courts have found at a minimum, 2 courts had found at a minimum probable cause, means it's likely that a 3rd court, that's actually looking at the issue would find probable cause. Now, it's not dispositive. The third court, the federal court, isn't going to say, well, those two municipal courts, I got to defer to them. But they look at the same things. They look at the same things. So in Chili's case, the court did look at probable cause for the qualified immunity on the 42 U.S.C. 1983 and found there was probable cause for that. It found there was probable cause for that, which is why the 42 U.S.C. 1983 wrongful arrest was dismissed, and they could only proceed on the state cause of action for wrongful arrest because qualified immunity didn't apply to the state one, so the court couldn't rule on it. But now at that point, at the motion to dismiss point, when you're looking at the state wrongful arrest charge, or not charge, but cause of action, now you had 3 courts, 2 state courts and a federal court who found there's probable cause. If an attorney or a pretend attorney or anybody else can't see that there's going to be a finding that there was probable cause despite the conviction or despite the appeal, the successful appeal, I don't know what to tell you. But a cop can have probable cause, and a prosecutor can prove probable cause, or defense can prove probable cause in a civil case very easily, even if the person that they're proving it against was innocent. 100% factually innocent. You could still have probable cause. The case that I was struggling to remember was like Hein, H-E-I-N, I think, versus North Carolina or South Carolina. I never remember it. It's one of those cases that the name just doesn't stick with me for reasons that I don't understand. But there, the cop saw a vehicle with one brake light out and one brake light still operable. He thought they had to have 2 operable brake lights. State law said they didn't. He conducted a traffic stop based on a misunderstanding of the law, thinking he had probable cause because a brake light was out. Ends up finding drugs, I think. They moved to suppress the drugs. This is where you see probable cause determinations getting appealed. They moved to suppress the finding of the drugs as fruit of the poisonous tree because they say, well, one traffic light satisfies the statutes. One brake light satisfies the statutes. So there was no probable cause. And the United States Supreme Court said, actually, in fact, officers can make reasonable mistakes of law. They could also make reasonable mistakes of facts. When you're looking at probable cause, you're looking at what the officer knew at the time he made the arrest, or at the time he made the detention or whatever. That's how you deal with probable cause. So the officer can be operating under wrong facts as long as he's reasonably operating under wrong facts or wrong understanding of the law, and still have probable cause. It's a very low burden of proof. So anyway, I hope this makes sense for all the slow boys out there and all the pretend attorneys, and God help me if it's a real attorney with 26 years of experience who doesn't understand this shit. Like one of the things that bothers me is the legal profession gets a lot of a bad rap. Because there's a lot of bad attorneys out there. There's a lot of attorneys who are just getting a paycheck, who don't know or care, or who offer opinions when they don't have a really good understanding of it. And I've given bad opinions before on my channel. Those videos are still up. And so I'm not blaming anyone for saying, lawyers are people, we can make mistakes, but man, having such a terrible opinion that overturning the conviction means there's no probable cause, and stomping your foot down and saying, I've been practicing law for 26 years. Just shockingly bad. First of all, I'd care. One of the attorneys that I do work for is, he's been practicing law for 53 years now. And that dude has some shit understanding of the law. And sometimes he wins despite his shit understanding of the law. And sometimes he loses, but it is what it is on that. But your credentials don't really mean anything to me. And let me just say again, sometimes attorneys are placed in a situation where they're representing someone, and that person, the facts or the law are just against their position, and they got to do their best with what they got. And sometimes the best you could do with what you got is to lose, because there's just nothing there, and you're getting paid to represent people. But as long as you're informing them, like, look, you don't really have much of a chance here, I don't hold that attorney. I don't shit on that attorney's parade. You know, attorneys are people. You know, everybody makes mistakes. I do shit on people like Darcy, who get their pants all inflated from huffing their own farts, and they file amicus briefs that are completely unfounded in the law, that are completely groundless, that just expose how ignorant they are of a subject. I do fault people like that. His hubris led him down that road. He wasn't representing the client on that. And like, he didn't have to expose how incompetent he was, at least in that field of the law. Which leads me to my last point. Apparently, people keep saying that Darcy said that I'm misusing hostile witness. Now, I mean, he's entitled to his opinion, but you can look at, like, Cornell Law University. You know, they have all the federal statutes up, and they also have a legal dictionary in there. If you look up hostile witness legal definition, you'll probably get that site. But I mean, you could really use any site as far as I'm concerned. And it means literally a party opponent that you call to testify, or I mean, they're technically a hostile witness if the other party calls them, because you're doing cross. They're not your witness. They're not a friendly witness. They're not on your side. They're a party opponent. You know, if the defense calls the plaintiff, they're a hostile witness, and so you, generally speaking, get a little bit more leniency on how you ask them questions. And if Darcy thinks I'm wrong, that's fine. I mean, I guess he could argue with, like, Cornell about it or whatever. But, you know, again, I guess if it makes him happy. Anyway, I've rambled long enough. Have a great holiday. Thanks for watching.